Hello, everyone. My name is Andrew Bartholomew. I'm with the Digimarc marketing team, and I welcome you all to today's webinar, Understanding Digital Copyright Protections in the Generative AI Age. We'll get started in just a moment, but first, a few brief technical notes. All the lines have been muted to reduce background noise. We do highly encourage you to submit questions using the webinar control panel. And even though we're doing Q&A at the end, please don't hesitate to submit your questions throughout the webinar. If we can't get to all of them, our speakers will do their best to follow up over email afterwards. In addition to Q&A, we'll also be incorporating some audience poll questions into today's discussion. There will be a total of 4 poll questions sprinkled throughout the webinar. We definitely thank you in advance for participating in those polls and look forward to discussing the results among our speakers. We are recording today's webinar, and we'll make that recording link available over email afterwards. I should note we do have a few slides that we'll display during the webinar to indicate our discussion topics, but today's webinar is really meant to be more of a conversation and a Q&A format than a presentation, so we will not be including a lot of descriptive slide content. Digimarc is very thrilled to be able to host such an important and timely discussion. For those who aren't familiar with Digimarc, we specialize in the application of covert digital watermarks on product packaging and multimedia, working with leading brands to deliver fast, accurate, and reliable digital product identification. Companies turn to Digimarc to identify and authenticate their digital and physical assets and protect consumers from counterfeits, automate error-prone manufacturing and distribution processes, and increase the quality and quantity of recycled materials through improved product and packaging sortation. We'll be hearing from an excellent trio of experts today. John Turanian is a founding partner of One LLP, where his practice focuses on intellectual property and entertainment litigation and counseling. John has handled high-profile disputes and transactions involving numerous legends from the worlds of music, film, fashion, theater, photography, literature, and athletics. A graduate of Harvard University and Yale Law School, John is the author of dozens of articles and 2 books, and his work has been widely cited in congressional testimony, federal, state, and foreign court decisions, and briefs before the United States Supreme Court in several landmark intellectual property cases. Joe Naylor is the president and CEO of Image Rights International, the global leader in copyright enforcement services for photo agencies and professional photographers. Joe's career spans more than 30 years in the design, development, operations, sales, and marketing of communications and internet-based services at efax.com, J2 Global Communications, and Web Messenger. In 2007, Joe began collaborating with professional photographer Ted Van Cleve on solutions to the challenges that commercial photographers, photo agencies, and media companies face with respect to online copyright protection. And in 2008, the two founded Image Rights International. Joe holds a BS in electrical engineering from the University of Texas at Austin, completed the program for leadership development at Harvard Business School, and serves on the executive board of the Digital Media Licensing Association. And finally, Ken Sickles is responsible for developing, delivering, and supporting Digimarc's world-class global technology platform that advances the reach and effectiveness of automatic identification of media across multiple industries. Ken has built his expertise with product technology and marketing over 25 years building software as a service products in both the B2B and B2C spaces. He has helped define, build, and bring multi-sided platforms to market from the ground up, as well as extend platforms currently in the market. Ken joined Digimarc from Think Tank, where he was the Chief Technology Officer and Chief Product Officer from 2017 through 2021, and was a key contributor in the acquisition of the company by Accenture in May 2021. His previous experience includes product leadership positions at One World Sync, Dow Jones, and Cognos. So we welcome all 3 of our speakers. And before we kick things off with our excellent panel, we want to get a lay of the land and start with a poll question about your current use of AI. So you should see that coming up on your screen here shortly. The question, which of the following best describes your current use of AI? Pretty simple question. Your options are content creation, content augmentation, or we do not use AI tools. So please go ahead and submit your responses now. And then we will go ahead and share those. So again, the question, which of the following best describes your use of AI tools today? Your answer options are content creation, content augmentation, and we do not use AI tools. I'll give it a few more seconds and then we'll wrap things up and I'll share the results. Okay, it looks like our responses are in for the most part. So I'm going to go ahead and close out the poll and then share the results. Interesting. So it looks like an even split for content creation and content augmentation at 38%. And then a quarter of our audience does not currently use AI tools. So a good indication that at least this particular audience is embracing the value of AI and using the technology to some degree, as we've seen other companies and other people do as this technology has really blossomed. We're going to transition now into our first topic and another poll question. So let me hide our poll and go back to our slides. So our first topic is understanding the impact of AI on copyright law. And we're going to hear from John here. But to kick this section off, we're going to ask our second poll question. And that is, which aspect of AI's use of copyrighted works concerns you most? Your answer options here are compensation, which would be the failure of generative AI companies to compensate rights holders when they use copyrighted works as training materials. Permission, the failure of generative AI companies to request permission to use copyrighted works as training materials. Transparency, which would be the lack of transparency as to what copyrighted works are being used in generative AI training materials. And then finally, crediting, which is the absence of crediting to show what materials are used when generating output to user prompts. So those options again, compensation, permission, transparency, and crediting. I see the responses coming in. We'll give it a few more moments and then I'll close out and share those results and then ask John his first question. Okay, it looks like our responses are largely in. So closing the poll and sharing the results, it appears permission captured a plurality of the vote, followed by transparency and then compensation and crediting, a fairly even split among transparency, permission, and compensation. So thank you again, folks, for participating in those. I'm going to go ahead and hide the results. So John, welcome to the conversation. Thank you for being here. First question for you, from a lawyer's perspective, what are the key legal issues to understand regarding potential liability for the use of creative content by generative AI companies?
Well, thanks, Andrew, for that question, and thanks to you, Andrew, Carly, and the entire Digimarc team for putting together this seminar. So the question actually is an interesting and complex one, and I just wanted to start out with a quotation from not Shakespeare or Mark Twain, because they didn't have anything fun to say about copyright, but rather from a famous copyright scholar who wrote the following. As a veteran listener at lectures by copyright specialists over the past decade, I know it's almost obligatory for a speaker to begin by invoking the communications revolution of our time, and then to pronounce upon the inadequacies of the present Copyright Act. Now that's Ben Kaplan. He wrote that in a book called An Unhurried View of Copyright, but he wrote that in 1966. And in a sense, it's a reminder that throughout the course of American copyright history, now almost 250 years, we have been responding, copyright has been responding to technological revolutions, whether it was the player piano in the late 1800s or early 1900s, radio, broadcast, television, cable in the 50s, 60s, and 70s, the internet in the 90s and 2000s. AI is a new challenge. And although congressional legislation may come along and kind of dictate some of the answers, I'm going to be operating from the premise that for now, as you can all know, Congress isn't really able to agree on much of anything, so we may not see much legislation coming through the pipeline. We got to deal with the current Copyright Act and how it's going to bend to the particular issues that AI presents to existing copyright doctrines. Now, all of you are familiar with the multitude of lawsuits that have been filed against AI companies in recent months, including the New York Times suit involving the use of newspaper content, the Illustrator lawsuit against Midjourney, the Getty lawsuit against Stability, which is taking place in the UK, George R.R. Martin and the Authors Guild lawsuit against OpenAI for use of books, Stellar Silverman suit also for use of books. So we have all kinds of content being litigated in terms of AI, and it raises some specific legal issues with respect to where generative AI may have liability under copyright and related laws. And basically, I'm going to say that there are really 3 points of potential infringement that are occurring with use of generative AI. First, there's potential infringement at the scraping level, which is the scraping of content for the training of AI. That involves obviously the gathering of copyrighted content and potential reproduction of it. Secondly, and relatedly, there's potential liability at the training level, which again involves reproduction, potentially even distribution of copyrighted materials to train these large language models that form the backbone of generative AI. And then finally, there is the user output, the product of the use of the AI. And this oftentimes invokes what's called the derivative rights doctrine, which is the exclusive rights of copyright holders to control not just reproduction of their work, but the creation of derivatives that are based on their work. Now, liability potentially can be found against the AI companies, but also against the users of AI content. With respect to AI liability, company liability, we're looking at potential claims of direct infringement or even potentially secondary liability against the AI companies, both in terms of scraping and training and also in terms of the user output. I will note that going after the AI companies for the actual user output is going to be somewhat challenging on a direct liability model, since the users are actually directing the action rather than the AI companies. And traditionally, a copyright law will not find direct liability against an entity unless they have what's called volitional conduct. And so there's probably a lack of volitional conduct by the AI companies in the actual user outputs. However, they can be held secondarily liable under copyright principles. Additionally, users face liability, and this has been a big issue because, as many of the listeners today are familiar with, some of the AI companies are now offering indemnification to users if they are in fact sued for use of generative AI output. How good this indemnification promise is anybody's guess. And this is yet to have been legally challenged, and it'll be interesting to see how long AI companies kind of stand up and back up their output with these indemnification provisions. Now, model training may in fact be an infringement. This is kind of at the source of the New York Times case. And, it raises some interesting issues because on one hand, the New York Times argues that its newspapers have been used to train OpenAI, and it gives some very convincing evidence of that in the complaint of user output coming in that really is almost direct copies of the New York Times, sometimes with incorrect assertions being attributed to the New York Times. However, at the same time, one of the big defenses we're going to see to both user output as well as scraping is the fair use defense. For all of you familiar with copyright law, the Supreme Court recently issued a decision in a case called Goldsmith v. Warhol this past term that seemed to cut back the transformative use defense in fair use doctrine But there is a body of existing jurisprudence over the last 15 years that may in fact favor AI companies. And here I'm pointing to the Google case involving the Hathi Trust and the Authors Guild, involving the redigitization of many books without permission for search engine purposes, and the Perfect 10 case involving thumbnails. In those cases, courts found that transformative uses of copyrighted content were protected under the fair use doctrine, and OpenAI, Stability AI, Midjourney are going to make an argument that what they're doing is transformative and for a different purpose because of the new technological applications of AI. And very importantly, there are issues regarding potential safe harbors that have been established in the past. Perhaps most notably is something called the Sony safe harbor. Many of you may be familiar with the famous lawsuit in the 1980s involving the legality of the VCR, where by a single vote in Sony v. Universal, the Supreme Court held that the VCR was not infringing and therefore sort of ushered in the era of all kinds of other technologies like DVRs, iPods, etc. But in that case, importantly, the Supreme Court created something called the Sony safe harbor, which says that for manufacturers of new technologies, they will be immunized from claims of contributory liability if their products are capable of substantial non-infringing use. Now, there's an argument here that the Sony safe harbor may be applied to AI and say AI is capable of infringing uses and non-infringing uses. And the court in Sony cautioned that we don't want legal doctrines, especially imposed by the court, to snuff out technologies, in that case, like the VCR, that are in their nascent period. Similarly, courts may feel inclined to do the same thing with AI and suggest the Sony safe harbor immunizes OpenAI and other major AI platforms from liability. The other point I want to make is that it's not just copyright infringement liability that we're talking about here. There's potential liability under the right of publicity, which involves the use of images, names, voices, likenesses, etc. Liability under trademark law. The New York Times lawsuit, for example, has a trademark claim for dilution, and potentially claims for unfair competition or breach of contract that have been brought in these AI suits, and related copyright claims, not for infringement, but for removal of an alteration of copyright management information. This would involve the removal of, for example, digital watermarking, something Digimarc provides as a service, from copyrighted works, which can facilitate further infringement and can also create additional liability for AI companies. So that's sort of a lay of the land.
Of course, laws are only as meaningful as they are enforceable. So maybe you could speak, John, to some of the key challenges that rights holders face in potentially enforcing some of the rights that you just laid out with respect to generative AI companies and the uses of these generative AI systems.
Yeah, there are some big challenges for rights holders. First, who do you go after, right? You can go after the AI companies, people who are perhaps facilitating the AI companies, but also you can go after the users. And of course, this presents a dilemma that's not too unlike the dilemma facing rights holders in the early internet era, which is fighting the scourge of piracy. Do you go after users? There were some lawsuits, those tended to generate bad press, but sometimes the actual AI companies themselves may find themselves immune for a variety of reasons, being offshore, because perhaps they've set up their systems in a way that evades copyright law, et cetera. So that's one challenge. Another big challenge is being able to show that your works in specific were trained on the AI. That's been a challenge, for example, in the Silverman suit. The New York Times lawsuit does a very good job of detailing how clearly the New York Times articles were the basis of the AI's training set. But in the other lawsuits, there have been real challenges. Recently, there was a leaked list from the Midjourney lawsuit that showed 16,000 artists that were trained on, that were used to be trained on Midjourney. That is something that came out in discovery, but courts may be inclined not to allow litigants to move into discovery if they can't prove with at least reasonable certainty that their works were actually trained on the AI. And then, of course, there's the question of what derivative outputs actually come to represent a copyright infringement. This is an issue that was raised recently in the Anderson lawsuit in the Northern District of California, where the court rejected the plaintiff's proposition that all output from AI is necessarily a derivative work, because you need to show some level of substantial similarity to an underlying work. And moreover, if you're going after AI companies and they're producing unlawful derivatives, the question is, if the derivative draws from thousands of works, is it infringing thousands of different rights holders? How do you apportion the damages? And how does that work? My suspicion is ultimately we're going to see what happened in the YouTube era, when Viacom went against YouTube for all of its piracy. And in the end of the day, although Viacom lost the lawsuit, a system was put into place by YouTube where licenses were gathered from rights holders in order to obtain permission, and a compromise, although uneasy, was reached between rights holders and the technology companies like YouTube that use the works. So we may see something like that. And I think, very interestingly, the New York Times lawsuit mentioned expressly that they had been in negotiations with OpenAI, and many big rights holders are currently.
John, you talked about derivative work, and the final question here is, what are the key issues to understand regarding the copyrightability and protection of that content that can be generated through AI, that derivative work? Are you able to copyright that?
Yeah, that's a big issue, and I think there's a number of lawsuits pending. Probably the most advanced is the Thaler lawsuit. Thaler is Stephen Thaler. He's a computer scientist that in 2019 created something called the Creativity Machine, and it generated autonomous AI output. He tried to register it with the Copyright Office. They rejected it, saying that copyright only inures in human creators, and this was a machine. We've seen a few other lawsuits, including cases involving the Zarya the Dawn case, et cetera, that have challenged this. And I think that ultimately, although the Copyright Office's current position is no copyrightability, there are a number of prior precedents that suggest there may be some copyrightability. Specifically, this issue was litigated 150 years ago with the advent of photography and the very famous Cerrone case involving the image of Oscar Wilde. And the question the court had to answer was whether a photograph was merely an act of science or there was authorship, in other words, authorial selection in the process. And the court said, really, it's both, but there's certainly authorship because of selection and angling and lighting and posing. And one could draw the same analogy to credit AI output with some level of human intervention with respect to the user prompt. So we may well see this coming down the pike, and we may see a revision of that. The Thaler lawsuit is currently on appeal before the DC Circuit, and amicus briefs and briefings are being filed right now. So, I think what's interesting is the concerns that were raised by the poll sort of show that people are split in terms of, rights holders are split in terms of what their animating concerns are. Certainly, a lot of people are concerned, perhaps most prominently, with the permission issue. But that, of course, permission ties into a lack of compensation. And people want more transparency, as evidenced by the poll question, with respect to the use of AI. And we're really only at the beginning of the era. So much is unformed in terms of the law, and it's going to be a fascinating time to see where things go. So I appreciate the opportunity to talk about it today.
I can only imagine what the world would look like today if the courts ruled differently about the copyrightability of photography 150 years ago. It would be a very different world for professional photographers. Well, really appreciate it, John. We're going to switch to our next topic, which is the practical application for rights holders. We'll bring Joe in for this section. I am going to kick it off with another poll question. This is our third poll question, and it should be appearing on your screen momentarily. The question is, how does the potential uncertainty around copyright ownership of visual assets created by generative AI affect your business strategy and risk management? So one way to think of that is, how does some of the ambiguity that John just addressed affect business decisions? Your options are to different degrees of concern, so highly concerned, which would be, you view the potential lack of copyright ownership of generative AI created assets as a significant legal and financial risk to your business. Moderately concerned, you recognize the risk, but believe there are sufficient measures you can take to mitigate them and still benefit from using generative AI. Somewhat concerned, you have some reservations about copyright issues, but do not see them as a major obstacle at this point to using generative AI in your workflow. Minimally concerned, you're obviously aware of the copyright discussions that are happening, but it has not yet become a pressing issue for your business. And not concerned at all. Your stance is aligned with that of many generative AI companies, which hold that content created by generative AI does not constitute copyright infringement. So that poll is up. We're collecting responses. I'm just keeping an eye on those votes that are coming in, and we'll close it here in just a second. Okay, I'm going to close the poll and share the results. It looks like moderately concerned received the highest number of votes, followed by somewhat concerned and highly concerned. Interestingly, only 15% of our respondents answered either not concerned or minimally concerned. So I think it's safe to say there is certainly some concern about what's happening right now, with seeing those results. So Joe, I'm going to hide the results and then bring you into the conversation. And my first question for you, Joe, is from a practical perspective. Could you elaborate a little bit on the importance of registering visual assets with the U.S. Copyright Office for rights holders, and talk a little bit about how that step provides leverage in pursuing infringement claims?
Yeah, absolutely. So first, thanks, Andrew, for having me. I appreciate the opportunity here. The operative word here is leverage. If you're creating works, you own works, whether you're a brand, you're a photographer just starting out, the number one most important thing you can do to protect your work is to register it with the Copyright Office. That is what provides the leverage should you become infringed at some point down the road. We recently had a pretty significant case, one which actually John Turanian and his team led, with Scott Hargis versus Pacifica Living Institute. And basically, that was a situation where a company had infringed Scott's work, and he, unfortunately, made it a part of his workflow so that whenever he created works for a job, he would register those with the Copyright Office. And in this particular situation, we took on the case from, approached the other company who's using it without rights. They took a rather unfortunate course, wouldn't cooperate, and in fact continued to even post new images of his on their websites. And had he been in a position where he hadn't registered with the Copyright Office, there was essentially nothing we could do. I mean, we could have registered the photos at that time. We could have filed a complaint, but you're kind of limited in what you can sue. It's really limited to actual damages or disgorgement of profits in that scenario. And actual damages for online use it's really just a direct function of your licensing rate. But having registered with the Copyright Office, having timely registration, the real key leverage is that it provides you the opportunity, if necessary, to pursue statutory damages and attorney's fees. In that situation, if those statutory damages could be up to $30,000 per claim, and if they were found to be willful, it could be up to $150,000 per claim. And so that puts you in the best position to pass your case to an attorney to handle it on your behalf. And in his case, it actually went to trial, which is extremely rare for these types of cases. And the jury awarded him $150,000 per photo for 43 photos. So it was pretty substantial. That's kind of an outlier. On an everyday basis, like, rights holders are infringed regularly. They've just come to not accept, but they just understand that's part of the landscape of being a creator. And frankly, the last thing they want to do is actually go to trial or even have to file a complaint. But just registering with the Copyright Office gives you that additional kind of just ammunition, if you will, to pursue a claim. So if you're just trying to settle something directly, typically the first question is asked, how do I know you really own this photo? Well, if you can present them the certificate, that overcomes that objection more often than not. and you can move quickly to a resolution that takes care of the claim for you without having to go the legal route. The other big thing that you can do beyond just registration and positioning yourself well should you be infringed is having very clear terms in your licensing agreements with your contracts. Again, whether you're just shooting and licensing through a photo agent, or you're shooting for brands in your contracts where you're retaining ownership, or if you're the brand itself and you've actually been assigned rights in the works, and so you're the actual copyright owner of these works. You want very clear language in the contract from a licensing perspective on how they can be used, what the rate is for that use, of the time period, and so forth, so that if there is an issue down the road, you can go back and say, look, these were the terms. It's absolutely infringement. There's no gray area here. And even if it's for other parties that infringe your work, you can refer to these agreements as the basis for your demand, for example, and putting some justification behind the numbers that you're trying to pursue. And that more often than not will facilitate, even out of court type resolution, or if need be, your best option to pursue it if you do need to go through court.
Joe, given the evolving legal landscape around generative AI and copyright, what other recommendations would you give to rights holders to navigate these uncertainties, and how can they proactively protect their work and respond to potential infringements?
Yeah, I mean, so this is where it gets tricky with AI, right? So the core thing you can do to protect your work is to register. What's different now with the use of generative AI is the fact that the Copyright Office current position is that there's not sufficient human authorship for works that are created using generative AI to be copyrightable. And it puts photographers and other creators in quite a sticky spot, because on the one hand, as so often it seems to happen every 5, 10, 15 years, that there's some kind of business process evolution or technological advancement, whether it's going to digital cameras or using Photoshop, whatever the case may be. Creators are often told, hey, you need to adapt or die. These things are going to happen, and you can either be with us or not and get left behind. What's so fundamentally different here is that, okay, you got to adapt and use Gen AI or die, but if you do that, you don't have copyright ownership in those works. And so what does that do to the market? And so, the Copyright Office, I give them credit, very early on last March, they came out with guidelines. When you register works, you need to very clearly state that you were using generative AI and kind of outline what your contribution was versus that of the Gen AI, and submit it. But the problem here is it's twofold. It's on both sides. Historically, the specialists at the USCO who have reviewed the copyright registration applications have had a very fact-based role. Were they all published within the same calendar year? If they were published before 1989, were they first published with the copyright note? There's all these very fact-based, kind of a checklist. Yes, 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 yes. And then they can issue the registration. And because of that, you have a high degree of certainty as a rights holder when you submit your application, barring any kind of strange outliers, you're probably going to be issued the registration number for that. But now you have the situation where the specialists are taking on a more subjective role and trying to discern whether or not there's enough human contribution for it to be copyrightable, and therefore they can issue the registration number. And so what that does to the rights holder is it creates uncertainty for them. They're paying the filing fees to register these works, but they're not sure if they're going to get that work registered or not. So it really causes a problem. So as a rights holder, you've got to stay on top of what guidance is coming out of the USCO. They did a notice of inquiry for copyright AI last year, and just to speak to the level of interest and impact of the market, frankly, there were over 10,000 responses to this NOI. And so what we're hoping to see out of this is more clarity around what the criteria is for there to be a sufficient level of human contribution for registration to be issued. And with that, you have a much better understanding of what you can do as both the creator and frankly, the brand of the client that's paying for this work to be done, if you're ultimately the rights holder, and understanding what you can do to protect it.
Joe, we've been talking a lot today about risk and recourse. Let's kind of switch gears. What opportunities exist for rights holders in the realm of generative AI? And how can they balance capitalizing on these opportunities while still mitigating those risks that we talked about associated with potential copyright infringement?
Yeah, the big one for me is the opportunity to actually license your content to be trained. So everybody, or a lot of people, focus on the fact that this training is done, that people are, these companies are scraping content off the internet, which many of them are, and that is a massive problem. But there are a lot of AI companies out there that are doing it the right way. I mean, you got companies like Bria and Vigil, where that's all about ethical AI, and they're going out and they're licensing the content, or they're having content created for the training and paying, whether it's the models or the creators themselves, royalties for that work based on what ultimately is generated from the models themselves by the ultimate users of those models. And so, as whether you've got years of visual assets as a company, or again you're a photographer that you're sitting on 30 years of rock photography that you've done, AI models want that content, and there's an opportunity to license that content and monetize your content in ways that you've never had before. And I think it's really important to follow what's happening with New York Times against OpenAI and some of the other agreements that are being negotiated or even recently signed between AI companies and the big media companies, because it's really blazing the trail for how to do just that, which is how to license your content for training. And it's going to be very interesting to see how a lot of these court cases turn out as it come to light over the next 2-3+ years, to kind of like set the playing field. Because right now there's just so much uncertainty. You're just not quite sure what to do as a user of the content, for example. And so I think it's it's just incredibly important to kind of stay on top of that. And then on the flip side, it's okay, what can you do to mitigate infringement of your work from being used for training specifically? And again, at the end of the day, if somebody's going to steal your photo, they're going to steal your photo. But you can put yourself in a position to be able to do something about it if you find out that indeed you were infringed by a given AI company. And that's one, again, I'll beat the drum until I can't beat it anymore, is registration. Ultimately, that's what's going to put you in the best position to pursue a claim if you find that you've been infringed. But there's things that you can do, whether it's ensuring that you have copyright ownership and other key information in the metadata, whether it's doing that through digital watermarking and so forth. That also actually provides other opportunities, in addition to just copyright infringement, going back to some of the DMCA 1202B claims that John had referenced earlier, where if they strip or remove your copyright management information, that's a whole nother type of claim that brings its own damages. So while there's huge opportunities in licensing your content for training specifically, there's still the things that you need to be doing to protect yourself when you're probably inevitably going to be infringed by these companies.
Yeah, thanks, Joe. It sounds like a common theme I'm hearing is there's a lot of uncertainty, and this is a conversation that we could definitely repeat 6 months a year, and we probably have much different guidance based on some of these big decisions and see how things shake out. So we're going to transition now to our third and final conversation topic. And this is going to be a conversation about technology considerations. We're going to kick it off with our final poll question. And that is appearing on your screen now. The question: to what extent has the rise of generative AI prompted you to look at technology solutions to better protect your digital assets? And the options are pretty straightforward. Your first option is you're not thinking about it. Your second is you're beginning to evaluate technologies. And the third is those that have already deployed a solution. So again, to what extent has the rise of generative AI prompted you to look at technology solutions to better protect your digital assets? Not thinking about it, evaluating technologies, and already deployed a solution. We will give it a few moments here, and then I will reveal the results. Okay, good. We got some good responses coming in now. And just a reminder while we're waiting for those, we should have a little bit of time, 10 minutes or so at the end for Q&A. So please do feel free to submit your questions. We'll try to get to as many of them as we can. If we can't get to all of them, we'll kindly ask our speakers to follow up over email and get those answered. Okay, I'm going to close out the poll and reveal the results. It looks like 59% are in the process of evaluating technologies, which is encouraging to see. 31%, about a third, are not thinking about it yet. And then a small section, 10%, have already deployed a solution. So interesting. I'd be curious how that result of that particular question will look in 6 months to a year. Anyway, I will stop sharing the results and we will jump in. So Ken, I'm going to welcome you to the conversation. Digimarc is focused specifically on digital watermarking. Would you give the audience a quick primer on that technology?
Yeah, thank you, Andrew. So I think digital watermarks are one of the coolest technologies that I've been a part of over the past, 30 years of my career. Now, I will acknowledge that I'm a bit of a self-described geek, so not everyone may think it's as cool as I do, but digital watermarks are really a hidden signal embedded in something like a digital asset. So embedded in an image or embedded in an audio file or a video that contains information about that digital asset in this case, and can be a bridge or a link to further information about that digital asset. And what that allows is for the different machines that are encountering an asset to learn more about that asset based on what is either contained in the digital watermark or what the digital watermark can connect that machine to. So it is this hidden signal that you can't see that really allows machines to understand better what sort of asset it's interacting with, and then to actually have different interactions with it. So just as an example, an image that contains a digital watermark can be scanned by a computer somewhere, and that computer then can realize, oh, this image is copyright protected, and I do not have the opportunity to use this without permission from the author. Just one example, but anything you want to be able to communicate about that particular digital asset can be either contained in the watermark or linked to by that watermark and shared appropriately. So what the digital watermark really does is give interactive capabilities to these digital things that they wouldn't normally have.
And how is digital watermarking that you just described, how is it different than other technologies that are used to convey copyrights today?
Yeah, that's a great question. So the key comes in the fact that the digital watermark is a hidden signal inside of the digital asset. So again, you can't see it. The human eye, cannot perceive the digital watermark. Whereas there are many other solutions. There is the IPTC metadata standard that can contain all sorts of information about the digital asset, including copyright information. There's an emerging standard called the C2PA standard that is very similar, contains that information. But but the existing standards are all based around metadata. Now, metadata is not actually embedded inside the digital asset itself. Rather, metadata is attached to that digital asset, which is great in theory if everywhere that digital asset were to travel, the machines and computers that it were encountering respected the fact that it had metadata attached to it and kept the metadata attached to that digital asset. However, that is actually very rarely the case. So let me give you an example. If you take a picture with your iPhone, there was a beautiful sunrise here in Boulder this morning I took a picture of, and if I were to upload that picture to my 17 followers on Twitter, the first thing that Twitter would do is strip away the metadata about that picture. Now there's technological reasons for that, size considerations, so how much storage are we using? There's also privacy considerations, right? That picture taken with my iPhone contains information about me and my precise location. So for example, social media platforms are kind of loath to allow that information to permeate throughout their networks. So now any of the copyright information that was also attached to that image has been stripped away. So now you have an image sitting out there on the internet that really has no linkage to you as an individual, has no information about whether this asset is copyrighted or not. And it becomes, I think, listening to John and Joe earlier, you really lessened your ability to assert your rights around that image because you're not conveying those rights to anyone at that point. So while metadata standards do exist and have been around for a long time, they unfortunately just aren't kind of respected by a lot of systems out there. And by the way, that includes internal systems. So if you have an application, you've got a digital asset management system internally that you store all of your images in, and then you send it over to some other system that may prepare that image to be posted on social media or an e-commerce site or a website, chances are one of the systems along the way will also strip off that metadata, again, either for technological reasons or for privacy reasons. Now, this is where, if we go back to the digital watermark and understanding that it's actually a hidden signal inside of that asset, now that signal can survive whether it is a normal workflow inside an enterprise preparing an asset to be distributed or posting to a social network or an e-commerce site, because it's not attached as metadata. It's actually, again, it's inside the image itself, in this case, that we're giving an example of. So that's how the two technologies are very, very different. And by the way, they are quite complementary, right? In many cases, a watermark, which survives all of this distribution and workflow and everything, can be linked back to the metadata. So if there's a ton of valuable information in the metadata, again, that watermark can serve as a bridge or a link back to that metadata, so that no matter where that watermark is or where that image is found, the watermark will likely be there, and then you can use it to retrieve information to convey copyright and all sorts of other things. So metadata and watermarks do go hand in hand, and I think just to sum up my very long-winded answer here is that watermarks survive a lot of the workflow and distribution channels that digital assets go through. Metadata does not survive most, in fact.
Ken, with insightful answers like that, I'm confident we can get your Twitter follower number up to 20 after today. Crossing my fingers for you.
Awesome.
A stigma that tends to follow watermarking around is that it can degrade the quality of an image or any form of digital content. Can you speak to the accuracy of that and maybe how the technology has evolved to correct some of that concern?
Yeah, no, it's a valid concern, right? I'm sitting here talking about how we can embed this watermark inside your digital asset, and whether it's audio or imagery, you wouldn't want to degrade that asset. I think there is the possibility, anytime you're embedding something directly into the binary bits and pieces of a file, there is an opportunity for degradation to happen. But luckily, there's also science behind what we do, and we can prevent that degradation. So along with science and about 30 years of practice, we are at the point where now a signal that's embedded in an image, for example, so an image or a video, we use color theory. so that where we embed that signal, we will put it into areas that the human eye cannot perceive, whether it's a color shift that really the human eye can't perceive, but a computer can. There's these really cool charts that can show you what humans can see, what computers can contain, and where the gap is between those. So we can hide it into the color. We can also hide it in the luminance of the photo, so the brightness and the darkness of the photo. So we have different ways to embed that signal, repeat it throughout the entire photograph without it actually affecting the quality of the image itself, which is of course the goal. The same thing for audio. As you can imagine, there are a lot of audio frequencies that humans simply cannot hear. That's a great place to hide a digital watermark signal inside of something like that. So while if you are experimenting with digital watermarks, you're not quite sure what you're doing with digital watermarks, you could certainly apply them in a way that it could degrade the quality of your digital asset. That's generally not an issue that we have here at Digimarc or our customers have, because we use all of these different sciences to help make sure that your asset is as pristine as it can possibly be.
Quick shameless plug here. Digimarc is planning to host a webinar next month, sometime in February, where we're really going to dive into watermarking and get into some of the science and sort of the state of the art that Ken just described. So look for an update on the timing of that webinar. But for anybody that's interested in really diving more specifically into the science and frankly the art of watermarking, that webinar is for you. And again, that should be coming up sometime in February. And Ken will also be speaking on that and continuing to grow his Twitter following. We're going to transition into Q&A now. Really appreciate some of the questions that have come in over the past 50 minutes. Ken, I'm actually going to stick with you because you just got done sort of talking about watermarking and the impacts that it can have. And I'm going to paraphrase this question a little bit, but the question is really, what do you see as the key to having this technology become more ubiquitous? Is it action from governments? Is it embrace from the big tech companies that can embed this technology into their devices at the hardware and software level? Just what are your thoughts on how this becomes more commonplace?
Yeah, what a great question. I think the answer lies really in two areas. I do think governments can have some influence here, whether it's through regulation, legislation, and/or requirements about the kind of software programs they procure to generate, store, and distribute content. That's certainly one area. I think that that area is something that I'm sure John can testify to this much more than I can. Takes a very, very long time. You'll generally find some inconsistencies as you move from one country to another country. So while it's helpful, it can be problematic. I think another area that we can see is companies who create the devices like my iPhone that create content, or the software platforms that generate and manipulate content, someone like an Adobe as an example, right? Or even camera companies like Nikon and Leica. They're another area where if they adopt the technology around the standards and around digital watermarks, again, going back to they're kind of peanut butter and jelly, if you will, that's a great way to get this technology to become much more ubiquitous, because it can actually be hidden behind the scenes, and most users don't even know they're leveraging the technology. They just end up getting the benefit of the technology, which I think is ultimately the goal that we're all going for. And not to give a shameless plug, but Digimarc does offer our watermarking software for free to device manufacturers, content creation platforms, and chip manufacturers, just so that can actually happen. I will say there's one other area where I think we can see the adoption of this technology really begin to take hold, and that is through the use of standards. So I mentioned the IPTC standard earlier. There's an emerging standard called the C2PA, or Content Credentials Standard, as some of you may know it. Standards are a great way to ensure that there is consistency across borders around how technology is being implemented and rolled out. Again, I think it takes the effort of the companies we were talking about before to adopt those standards. But when you put the two together, it's a great way to get this technology to become ubiquitous. And I think there's there is a bit of a responsibility, that I think everyone bears here. The contents that share platform, the contents that monetize platform, the contents that create platform, the devices that create content, and the devices that do. We're really, really early on in our information age. If you take a step back, and I think in order to get to a place where everyone's rights are being respected, where we can ensure that bad actors aren't jumping in and creating AI imagery or video or audio that's used to deceive and defraud people, the adoption of this technology, the adoption of these standards will help prevent that. And I think technology companies as a whole really owe it to their user base that they're monetizing, and to adopt these sorts of standards and technologies. I could go on for much longer, Andrew, but I'm sure no one wants to hear me on my soapbox for too long, so I'll leave it at that.
Well, I also want to invite perhaps Joe, you to weigh in. I know that watermarking obviously comes up in your business as well. Any thoughts from you, Joe, just on the state of standardization, the ubiquity or lack thereof of these types of technologies, and how you think that's going to evolve over time?
Yeah, I mean, as far as using digital watermarking and other technologies, that there's a clear path to addressing the issue, especially on the training side. I kind of look back at the DMCA, and I've always considered one of the biggest failures of the DMCA was this notion that the statute talks about this industry consensus of all actors in the marketplace to come together to decide what technical measures could be implemented by the platforms to mitigate or eliminate infringement. And of course, social media platforms and so forth, and the rights holders, they're just inherently not aligned. You're just not going to get consensus. So I think there has to be some degree of mandate as far as what technology is implemented to address these issues. And I think we're running into essentially the same issue again between the AI companies and the creators and their works being ingested for training purposes. And the platforms are in complete control, and the rights holders are just saying, hey, that's my stuff, what can I do? So they're pretty much limited to doing the things that they can do to protect themselves should they become infringed. But there's there's not a lot of power in their hands to prevent themselves from being infringed. So if you had some kind of system where you're mandating technology needed to be implemented by the AI companies such that they have to scan the proposed content that they would like to ingest for training purposes to do some minimal check to determine, is this content available to be trained? Is there data within it, whether it's metadata or within the digital watermark saying, no, this is not available for training, or if it is, XYZ. Basically implementing the technology on both sides to better regulate what's coming in order to minimize the infringement that's taking place on an insane scale right now. And so I think, look, I come from the tech side. I get that there's cost and expense with implementing these solutions. So it's not an easy thing to put in place. And anytime you bring in the government, there's going to be a lot of issues there too. But there has to be some kind of medium line. And frankly, it might come out of all the litigation that's occurring between the AI companies and the big media companies, which actually can afford to put up the fight to make sure these systems can be put in place.
John, I think we have time for one more question. I did want to get to this because I think it's an interesting one. All the way back at the beginning, you talked about derivative works and the copyrightability of those. And there's been a couple cases that have sort of posed that question. One of our audience members wanted to know if that copyrightability would be impacted if the derivative, if the final output was derived from a single author's work. And the example I was thinking of here is take perhaps an author of of many novels, crime novels or something, and you could feed that, just that content into the algorithm and spit out a new fresh novel, would that be more fundamentally copyrightable because it was derived from a single author's corpus of work?
Well, it's a good question. I think it would make the questions surrounding the copyrightability a little bit easier because you wouldn't have competing claims from other authors. That said, to properly understand the Copyright Office's position, at this point, they would say it still doesn't matter because what is occurring is not human authorship. The actual authorship, the particular output is being done through a machine. And so drawing from the case laws the Copyright Office has, saying basically humans don't get authorship. Humans only must be authors. And this goes back to the famous monkey selfie case, the Naruto case. You still have that issue being posed. So I think it would make it less complicated, but you still have the hurdle of what about the human input? What is the human input going in there? And I think the argument you would make there is if it was a single author and you're drawing from that author's corpus, you're basically saying the ingenuity and authorship is entirely that one author's with a little bit of machine magic thrown in. And if that's the case, how is that different than photography?
That's a very fair point. Well, unfortunately, we'll have to end the conversation there. For those of you who did submit questions, I saw we had a flood of them come in very late, and we couldn't get to those. Obviously, we will share those with our speakers and do our best to get those responses sent over to you over email. Again, a big thanks to John Terani and Joe Naylor and Ken Sickles for sharing so many great perspectives and insights. I thought this was a fantastic discussion. On the screen, you'll see email addresses for John, Joe, and Ken should you wish to get in touch with them directly. They'd love to continue the chat. You can follow up on anything you heard today. As a reminder, we will be following up over email with a link to the recording, and we definitely encourage you to share that with anyone who may be interested in the topic. Thanks again, everyone, for joining, especially participating in those poll questions, and have a great rest of your day. Take care.
Thanks, everyone.
Yes. Thank you, everybody.